Good morning, everyone. Alistair Trent here on September 18th, 2020, and today I'm going to be speaking about the just released Bill 204, Helping Tenants and Small Businesses Act 2020, which is the anticipated rent freeze legislation that was announced a couple of weeks ago that will take effect in Ontario for 2021. And this is just the summary section. The Act obviously amends a number of pieces of legislation. In relation to the Residential Tenancies Act, the summary is as follows. The schedule amends the Residential Tenancies Act to provide for a residential rent freeze for the calendar year 2021, subject to specified exemptions, which of course we'll get to. The schedule provides that the guideline for rent increases is 0%, despite the guideline that was published under 123 of the Act in the Ontario Gazette for 2021, and the Lieutenant Governor in Council is given the power to make regulations concerning the transitional matters arising from these amendments. So with that, we will get to the amendments themselves. So this is Schedule 7 of the draft legislation dealing with the rent freeze. And the first section obviously just amends the legislation to insert a subsection saying the guideline for 2021 is 0%, despite the previous guideline that was published, and the minister is not required to have the new guideline published. The next part deals with the actual rent freeze. The rent freeze period means the entirety of 2021 from January 1st, 2021 through to December 31st, 2021. And the next is the operative part relating to the exceptions or non-application of the freeze to certain rent increases. So the section doesn't apply to, first of all, accommodation described in Clause 6.1 sub A or B, that is care homes and developmental or group homes for people with developmental disabilities, not to be confused with 6.1, which is the exemption for new condominiums and those other type of properties which are still frozen. The next one is an increase in rent for a rental unit taken in accordance with an agreement under Section 121 or 123. So if you've already made an agreement with a tenant to increase the rent for one of the permitted reasons, either you're going to do work or add services, etc., then that agreement is still in effect. An increase in rent for a rental unit permitted under Section 126.10 or Section 127. These are the sections that allow a landlord to apply to the Landlord and Tenant Board for authority to increase the rent based on various grounds. And this is the area in which most of the clients have questions relating to how this rent freeze is going to affect their current outstanding increases in applications. So the increases in applications, or the increases that are exempt in this manner, are first of all an extraordinary increase in the cost of municipal taxes and charges in paragraph 1 of subsection 126, if the increase in rent is permitted by an order of the board that was issued before the Helping Tenants and Small Businesses Act 2020, this legislation, receives royal assent. The next one is an application based on eligible capital expenditures as described in paragraph 2 of subsection 126.1. And the third one is an application based on operating costs relating to security services as described in paragraph 3 of subsection 126.1. This is somewhat interesting, and we'll see what developments happen because, to my mind, I'm struggling to see the reasoning behind this. If you've already paid an extraordinary increase in municipal taxes, and you've made an application to recover the tax costs from the tenant, then it would appear that your right to recover the taxes from the tenant depends solely on whether or not the board gets around to issuing the order before this legislation goes into force. Just from a mechanical type of a process. So we have a number of applications outstanding for these increased taxes. The board hasn't issued orders on any of them, and I suppose it's almost like a race to see whether the board will issue the order before the legislation goes into force. But I'm struggling to see why an application based on an extraordinary tax increase would have that qualification in it, whereas if you've spent the money on capital expenditures or security services, then the application just goes through. It's only if the application is based on taxes that the application prevailing is subject to the order being issued before the legislation goes into force. That's rather interesting, and we'll see if any further clarification comes in relation to that. The other, big question, which isn't in this legislation, but hopefully will be in the transition, is what of those increases where landlords are already given a notice of rent increase based upon the previous guideline and an additional, amount for, that they've made application for. Like they've made application for another 2%, and they've given a rent increase based on the 1.5% plus the 2 for 3.5. Does the fact that the guideline is now 0 automatically reduce that notice of rent increase to just 2%, or does the landlord now have to give a new notice of rent increase for the 2%, all over again? So that'll hopefully be revealed in the transitional provisions or regulations that are subsequently made, or it may in fact be addressed as this bill moves along and is amended, through the various readings. So again, thank you for joining me. If you found this video informative, please like and subscribe to my channel. And I'm Alistair Trent on September 18th, 2020. Thank you and have a great day.